Please proceed.
Good morning, Your Honors. Drew Broadus for the defendants' appellants. I'll wait the free fire period. I would like to try to reserve 2 minutes for rebuttal.
How long?
2 minutes.
Okay. Good luck with that.
So, as you're probably aware, this is the tail end of a business divorce litigation that was settled in 2008. That was reduced to a settlement agreement that ultimately gave rise to this breach of contract action. We asked this court to review 3 issues, 2 of which would result in a new trial. The third deals with the post-trial award of attorney fees, and that is the issue that the court requested supplemental briefing on. The other 2 issues I want to point out, I think they're very important. I think there's jurisprudential significance to those as well. They go to the core of the court's gatekeeper function, whether this individual, Mr. Baldwin, was or was not an expert, whether he was giving expert testimony. The second issue I think is also very important in terms of what we perceive to be an arbitrary limitation on our cross-examination of Mr. Baldwin. I also want to emphasize that if there were a new trial on those issues, it wouldn't necessarily negate this attorney fee issue that the requested briefing is about, because at that point it would be a remand instruction as opposed to locking off part of the verdict. So with that in mind, it seems to be relatively undisputed, although the precedents from the Court of Appeals, that when attorney fees are sought under a contract, they're damages.
Can I?
Sure.
It is entirely, I think you have to think more clearly about some of these things. Contract attorney's fees can take multiple forms. It can be a incurred cost. I've already expended attorney's fees as a part of a contract, and if they're already liquidated and therefore incurred, I agree, they can be damages. Unfortunately for you, the contract here does not involve liquidated damages in the form of incurred fees. It authorizes a recovery if the party is a prevailing, it prevails at trial. And your position seems to me to require that before the condition precedent has been established, that is, that you have prevailed at trial, the party seeking attorney's fees under that provision has to submit those as a jury submissible issue. Does that make sense to you?
It does. It does.
I'd like to know why.
Well, all damages in any form presuppose that you're a prevailing party. If you're in an injury case, bodily injury case, duty breach causation
that's
have to
not
be
true.
proven.
I just gave you a hypothetical in which you have already incurred attorney's fees which are contractually undertaken, so that if you incur the fees, they become part of your contractual entitlement. Those are damages that are already liquidated. If your right to the fee is contingent, then I don't understand how you get to present that if you have to have the contingency met first.
Well, the reason why stems first from the fact that they are damages. Any element of damages has to be proven at trial and presupposes that you win.
I'm not sure I actually think that attorney's fees in all circumstances are damages.
Okay, well,
I do agree that if the contract permits them and you've incurred them before the trial, those are damages.
They're certainly a completely different animal than recovery under a court rule or a statute that specifically says that they're an element of cost.
Well, I think part of our
trial
jurisprudence has completely bollocksed the relationship of fees recovered by statutes, court rules, and those by contract. So that's why I'm being very, very aggressive in suggesting to you maybe we need to disaggregate these things and make sure that we are understanding doctrinally what we're talking about when we say damages that happen to be attorney's fees.
There's a point I'd like to make about that, and it's not to dodge your first question, because I understand there's a question that I probably haven't answered to your satisfaction yet. But to the extent that it's been bollocksed, I think we need to keep in mind that all attorney fee awards are, to some extent, an aberration from the American rule. And then after that, common law, you didn't get attorney fees unless.
Right.
So everything that we're dealing with is the unless. And also, the contractual attorney fees are an aberration to all of the other unlesses that are provided by statutes and court rules that all specifically say you do it after trial. So to the extent that it's been messed up in the intermediate appellate level,
do you think it's
why.
impossible contractually, I mean, if the contract said, attorney's fees shall be awarded by the court to the prevailing party, would you if that were the contract in question, would you contend that those fees had to be presented to the trier of fact?
Yes, I don't think that's fundamentally different from the language you're dealing with here. I think that the linchpin of their
So you're
argument,
saying contractually the parties can't even designate that the attorney fee question has to be decided by the court rather than the jury?
I'm sorry, I maybe misunderstood the question. You're saying, there's no doubt the parties could stipulate in the agreement.
Okay. So if the parties
They
say
could take it away.
the prevailing party shall have the fees determined by the court,
I think the court would need more elaboration. That might be an ambiguous clause because a jury is the court, the judge is the court in certain situations. You could phrase it in such a way that says they can be imposed as costs after trial, for example, and then I wouldn't be here today, if that answers that question.
Okay.
But this didn't say that. So the linchpin of their argument is that the clause prevailing party essentially does what that language would do. And I don't think it does, for one, because generally they are damages, and you prove your damages at trial. You don't come back, for example, if they thought there was all these other Gordie Howe memorabilia things that they forgot to talk about that they found. They couldn't come back for a second bite at the apple in a motion and say, look at all these other damages. It just doesn't work that way. The ship has sailed. And the Pransky case from the Court of Appeals, that's one of the only published cases we have, says just that, more or less. It says you can't do through a post-trial motion what needed to be done at trial. It doesn't go as far as I needed to, admittedly, because it doesn't specifically say you needed to do this at the jury versus in the pleadings. The Pransky case focuses on pleadings, but there's an important quote in there that I think is a big part of this. The other aspect of this particular case that I think answers your question is, by the time we got to trial, damages were the only thing left. We had already lost on summary disposition. We had already had an interlocutory application denied.
My questions supposed that there are some kinds of species of attorney's fees that are properly considered compensatory and some that probably aren't compensatory, and that they are, if you think of damages as money claimed to be paid for a person's loss or injury, I'm not sure that all attorney's fees provisions are that kind of damage. I think it's entirely possible that attorney's fees could be a penalty or any other thing that isn't compensatory. Liquidated damages.
Liquidated damages, and then you'd have a figure, and then, obviously different contract language could do all sorts of different things.
Well, the question is what this language means. If you conceive that all attorney's fees, contractually authorized attorney's fees, may not be damages in the compensatory side, then what we are talking about is whether this language creates a compensatory attorney fee or something that's not.
Well, what the language says is, I'm quoting from paragraph 5 of the settlement agreement, in addition to any other remedy, so I'm not quoting now, this is me, you're talking about a constellation of remedies, one of which is attorney fees, in addition to all the money that you think you get if we wreck the Gordie Howe memorabilia that's irreplaceable. And then actual costs of attorney fees incurred in the enforcement. So you're talking about something you've actually incurred at that point. So
At what point?
At the point that when you close your proofs at trial, and here is everything that I want the jury to think about and look at and award me.
You're not even a prevailing party at that point.
Well, two things about that. In this case, they'd already prevailed on liability. We were only going to trial on damages. If they got $1, they were a prevailing party. Arguably, they are a prevailing party. This isn't something we
Do they have a judgment?
Well, no, but they had summary disposition ruling in their favor that they were entitled to their damages. And the only remaining question at that point was what were their damages. So,
and so there was a trial on damages.
Damages only at this point.
Okay.
So The only way they're not a prevailing party is if they fail to prove a penny.
So if the only damages that a plaintiff suffers in a breach of contract case are attorney's fees, can the plaintiff prevail?
I suppose so. I'd have to really think about what sort of contract
Well, if
that would be.
if it's an element of a breach of contract claim, one would think that he could prevail if the only damages are attorney's fees.
And maybe some other, I mean,
No,
I guess I'm
not
struggling
something
with
else.
why you'd file the suit in the first place, just to incur attorney fees. I suppose there could be some sort of injunctive relief or something specific performance. I don't know. I could conceive of it, yes, where your only damages are attorney fees, I guess, if you had some other remedy involved.
No further damages would be necessary.
If you only went to trial, again, I'd have to know what other things this contract deals with, because practically I don't know why you're going to the courthouse just to sue to incur fees, but let's assume that there's something that you had to
So there are a
do.
lot of them.
Well, I mean, let's assume that the contract provided that
Maybe you were
didn't-
pursuing something else, but you just didn't succeed.
Okay. Again, not, in the hypothetical record, I don't know what else. You have to prevail on something under this language. You're saying to take this language and imagine that they didn't prove anything except for their attorney fees? Yeah, I mean, attorney fees are damages, so I suppose that they would have damages at that point. The problem with this case is that nothing was put in about the attorney fees until after the jury was over. So we have basically in the supplemental briefs, it kind of came down to a battle of the unpublished Court of Appeals opinions to some extent. The most, I don't know to what extent the Court's interested in Court of Appeals, even precedent at this point, if there's nothing from the Supreme Court on this, but I put some emphasis on this case, Barton Spencer. I think the Court of Appeals, although they didn't publish it, there's a leave application pending in this court, by the way. I haven't had time to act on it yet. In the Barton Spencer case, the court went into some detail and basically said that this defendant, even though they weren't a prevailing party to appeal, when they came back to the trial court, it was too late because they didn't put any proofs into their attorney fees at trial. And it got into the fact that to award them on a post-trial motion would essentially be depriving a party of their right to a jury trial on the issue. Now, plaintiffs pointed out in their response, well, you didn't specifically say jury trial when you opposed the post-trial motion, which is true. But we opposed it. We said you can't do it this way, and we preserved our right to a jury trial on all issues if there was a jury demand by us in this case. So those same concerns that the Court of Appeals expressed in Barton Spencer apply here. We had a right to a jury trial on every aspect of their claim. We timely requested it, and we didn't get it on the attorney fees. The case, and then to the extent they placed some emphasis on another unpublished case from the Court of Appeals, Roberts. Again, it does reach a result that helps them. I can't deny that. But if you look at it, and if you look at Justice Sarwood, a concurrence in the leave denial in that case is just a mess. And
You have less than 2 minutes.
okay, I appreciate that. I just want to say to the extent they're placing emphasis on Roberts, history of that case is such a mess that even as a persuasive authority, there's no rule that we can really derive from that. There was a combination of some misconduct by the judge not following Court of Appeals orders and law of the case layered on top of that. So we're more or less writing on a clean slate, but the Court of Appeals has consistently held that these are damages. So the question is, why wouldn't we prove them?
Okay, thank you, counsel. You've got
Thank you.
minute and 25 left.
Still a few minutes for morning, so I'll say good morning to you. My name is Steve Maddow. May it please the court, I have the honor to represent Gordie Howe, the state of Gordie Howe now, and Power Play International. I do not believe that this court should find that it's been a sufficient basis for the court to grant leave. I don't believe that the decisions below are clearly erroneous or an abuse of discretion. I don't believe there's a cause of material injustice to be seen here. More importantly, the issues involved really don't involve a legal principle of major significance to the state's jurisprudence. This is a simple contract case. We contracted that they must be a prevailing party, or we must be a prevailing party, before the right to get attorney fees is triggered at all in the contract. The Court of Appeals, the trial court, correctly found that and reached the right decision. If the defendant were correct now, then they should never, for example, have moved for attorney fees on their counter complaint, because under no circumstances after we were declared the summary disposition winner on the liability issue could they ever be prevailing party. And that's not how it was contractually agreed. That's not what was intended by the parties in their contract. This isn't the type of contract that in some of the cases that have been cited, it's a unilateral right to attorney fees based on a promissory note and incurred fees as part of a collection. In that instance, it might be that you need to prove them as part of your case because you incurred them as part of the collection process and they're already a liquidated amount. For example, that might have been the case here had we sought attorney fees in the first lawsuit of 2007 where we achieved the settlement agreement. Had we said the breach of that agreement caused those attorney fees, we would have put those into the record. That's not what we sought here. The problem here is that we were being asked to put attorney fees in, at least now after the fact. They didn't say it at the time. But now we're being asked to put attorney fees in as the trial is going on. And when we conclude our proofs, they then apparently would have put their claim for attorney fees in on the if come that one of us might become a prevailing party. And that doesn't make a lot of sense from a lot of practical standpoints. Certainly not fair to the plaintiff who concludes their proofs well before the defendant concludes theirs, and we may have to ask the jury to speculate on how long the trial will last, on how long the deliberations will last, whether there'll be rebuttal. So it's really not fair to us. We couldn't actually ask them to do that. We could always move, I suppose, to reopen the proofs, but again, we're putting procedural layers on something that is unnecessary. And in fact, I don't believe agreed to. The fact that the parties negotiated arm's length a settlement agreement with attorneys that required prevailing party language indicates that there is a predicate before you can get your attorney fees. And that predicate is you must complete and prove an entire breach of contract action, which means damages that are related to that breach, not just attorney fees. Contrary to counsel's answer to Justice Young's question, I don't believe that you could have just tried this case on the basis of our attorney fees only. You needed to have, to be a prevailing party, you needed to be able to connect their breach to damages that were caused as a result before we are triggered to be able to give a claim for attorney fees. And the proper method is to do that by post-judgment, and I think we did that. There are a number of different cases that have been cited that are unpublished. I know counsel made reference to one published decision, the Pransky case. In that case, they actually, the court found that there was no pleading that recognized a claim for attorney fees. We've actually properly pled the claim. The issue there is completely different, and I don't believe the Pransky case provides any guidance in the current situation. The other case that counsel referenced is Barton Spencer regarding the right to a jury trial. And again, that's not before you here because there was never a question raised or objected to by the defendant saying they were denied a right to a jury trial on the issue of attorney fees, either as to their countercomplaint or as to our claim for attorney fees. So I don't believe that that case helps here at all. It's not really before the court and the right to a jury trial issue. So here, I think it's really very straightforward that the trial court and the Court of Appeals made the right decision and handled it in the appropriate manner in accordance with the party's contract, and therefore I'd ask that you deny leave. If you have any questions, I'd be happy to answer.
Any questions? Thank you, counsel.
Thank you very much.
You've got about a minute and a half left, Mr. Broadus.
Thank you. I'd like to use it just to briefly address the notion that because not all of the fees have been incurred yet, that it would be unduly speculative. There's all sorts of situations where juries are asked to assess fees into the future. There's specific jury instructions in, for example, personal injury cases where they do this. So there's no problem inherent in the fact that they would have to go to the jury and say, okay, how much do you think we'll incur during the defense proofs, for example? It's not a reason to make this all be a post-trial motion, even if that were
Under your scenario, the jury would give future damages of some sort in terms of future attorney
He
fees?
could ask for it, sure, if he's...
All right, I got you, but then I'm just trying to
And then
keep
we
in my
would
mind.
say, you know, we grossly overestimated. I mean, it wouldn't
Then we
be-
go back to the judge on the issue of whether those fees are reasonable and have a whole nother hearing with all the same evidence and all the same testimony?
Well, this would be at the end of their proof, so we don't have to have a hearing. We would go and at some point in our proof say you totally overestimated.
Is there any limit on what the jury comes up with? If they say, we're going to give you $3 million?
Well, they
for
got to
attorney fees.
For example, how many hours they worked to date, the rate. In this case, it's not a reasonable rate; it's actual. So there's a layer there that's peeled off that we don't have to deal with that we normally would deal with in, for example, the case evaluation rule. So it would be a matter of giving their bills and then saying, based on the work we've done through our proofs and the post-trial, pre-trial motions and whatnot, that what do you think we're going to incur in 3 more days or 4 more days, or whatever they think the trial's going to go for. And if it doesn't, we can stand up there and say, you know what, we only spent 1 day, we only spent 2 hours in our proofs, for example. Then you slice down.
You've never
their
been a
award accordingly.
consumer of lawyer fees, then I take it.
I'm sorry, what?
Nothing, sorry.
Don't listen to him.
Does anyone have any further
Think I'm out of time.
questions? Thank you again. Thank you, counsel. The case is submitted. We stand in recess.